Section 4. The Constitution not only binds nobody now, but it never did bind anybody. It never bound anybody because it was never agreed to by anybody in such a manner as to make it, on general principles of law and reason, binding upon him. It is a general principle of law and reason that a written instrument binds no one until he has signed it. This principle is so inflexible a one that even though a man is unable to write his name, he must still make his mark before he is bound by a written contract. This custom was established ages ago, when few men could write their names, when a clerk, that is, a man who could write, was so rare and valuable a person that even if he were guilty of high crimes, he was entitled to pardon on the ground that the public could not afford to lose his services. Even at that time, a written contract must be signed, and men who could not write either made their mark or signed their contracts by stamping their seals upon wax affixed to the parchment on which their contracts were written. Hence the custom of affixing seals that has continued to this time. The law holds, and reason declares, that if a written instrument is not signed, the presumption must be that the party to be bound by it did not choose to sign it, or to bind himself by it. And law and reason both give him until the last moment in which to decide whether he will sign it or not. Neither law nor reason requires or expects a man to agree to an instrument until it is written, for until it is written, he cannot know its precise legal meaning. And when it is written, and he has had the opportunity to satisfy himself of its precise legal meaning, he is then expected to decide, and not before, whether he will agree to it or not. And if he do not then sign it, his reason is supposed to be that he does not choose to enter into such a contract. The fact that the instrument was written for him to sign, or with the hope that he would sign it, goes for nothing. Where would be the end of fraud and litigation if one party could bring into court a written instrument without any signature and claim to have it enforced upon the ground that it was written for another man to sign, that this other man had promised to sign it, that he ought to have signed it, that he had had the opportunity to sign it if he would, but that he had refused or neglected to do so? Yet that is the most that could ever be said of the Constitution. The very judges who profess to derive all their authority from the Constitution, from an instrument that nobody ever signed, would spurn any other instrument not signed that should be brought before them for adjudication. Moreover, a written instrument must, in law and reason, not only be signed, but must also be delivered to the party, or to someone for him, in whose favor it is made, before it can bind the party making it. The signing is of no effect unless the instrument be also delivered, and a party is at perfect liberty to refuse to deliver a written instrument after he has signed it. He is as free to refuse to deliver it as he is to refuse to sign it. The Constitution was not only never signed by anybody, but it was never delivered by anybody, or to anybody's agent or attorney. It can therefore be of no more validity as a contract than can any other instrument that was never signed or delivered. Section 5. As further evidence of the general sense of mankind as to the practical necessity there is that all men's important contracts, especially those of a permanent nature, should be both written and signed, the following facts are pertinent. For nearly 200 years, that is, since 1677, there has been on the statute book of England, and the same in substance, if not precisely in letter, has been reenacted and is now in force in nearly or quite all the states of this Union, a statute the general object of which is to declare that no action shall be brought to enforce contracts of the more important class unless they are put in writing and signed by the parties to be held chargeable upon them. The principle of the statute, be it observed, is not merely that written contracts shall be signed, but also that all contracts, except those specially exempted, generally those that are for small amounts and are to remain in force but for a short time, shall be both written and signed. The reason of the statute on this point is that it is now so easy a thing for men to put their contracts in writing and to sign them, and their failure to do so opens the door to so much doubt, fraud, and litigation that men who neglect to have their contracts of any considerable importance written and signed ought not to have the benefit of courts of justice to enforce them. And this reason is a wise one, and that experience has confirmed its wisdom and necessity is demonstrated by the fact that it has been acted upon in England for nearly 200 years, and has been so nearly universally adopted in this country, and that nobody thinks of repealing it. We all know, too, how careful most men are to have their contracts written and signed, even when this statute does not require it. For example, most men, if they have money due them, of no larger amount than $5 or $10, are careful to take a note for it. If they buy even a small bill of goods, paying for it at the time of delivery, they take a receipted bill for it. If they pay a small balance of a book account, or any other small debt previously contracted, they take a written receipt for it. Furthermore, the law everywhere, probably, in our country as well as in England, requires that a large class of contracts, such as wills, deeds, etc., shall not only be written and signed, but also sealed, witnessed, and acknowledged. And in the case of married women conveying their rights in real estate, the law in many states requires that the women shall be examined separate and apart from their husbands, and declare that they sign their contracts free of any fear or compulsion of their husbands. Such are some of the precautions which the laws require, and which individuals, from motives of common prudence, even in cases not required by law, take to put their contracts in writing, and have them signed, and to guard against all uncertainties and controversies in regard to their meaning and validity. And yet we have what purports, or professes, or is claimed to be a contract, the Constitution, made 80 years ago by men who are now all dead and who have never had any power to bind us, but which, it is claimed, has nevertheless bound 3 generations of men, consisting of many millions, and which, it is claimed, will be binding upon all the millions that are to come, but which nobody ever signed, sealed, delivered, witnessed, or acknowledged, and which few persons, compared to the whole number that are claimed to be bound by it, have ever read, or ever seen, or ever will read or see. And of those who have ever read it, or ever will read it, scarcely any 2, perhaps no 2, have ever agreed or ever will agree as to what it means. Moreover, this supposed contract, which would not be received in any court of justice sitting under its authority, if offered to prove a debt of $5 owing by one man to another, is one by which, as it is generally interpreted by those who pretend to administer it, all men, women, and children throughout the country and through all time surrender not only all their property, but also their liberties, and even lives into the hands of men who by this supposed contract are expressly made wholly irresponsible for their disposal of them. And we are so insane or so wicked as to destroy property and lives without limit in fighting to compel men to fulfill a supposed contract, which, inasmuch as it has never been signed by anybody, is, on general principles of law and reason, such principles as we are all governed by in regard to other contracts, the merest waste paper, binding upon nobody, fit only to be thrown into the fire, or if preserved, preserved only to serve as a witness and a warning of the folly and wickedness of mankind.